All rise. Veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Thank you very much. Court officer, please place the case on the record.
Good morning, Mr. President, Your Honors. The situation in Darfur, Sudan, in the case of the prosecutor versus Omar Hassan Ahmad al-Bashir. Case reference ICC 0205 109, and for the record, we're in open session.
Thank you. Appearances, please, beginning with the appellant, Jordan.
Of the Netherlands, and this is my colleague, Mr. Amr Hadid, who is a diplomat at the Embassy of Jordan to the Netherlands.
Thank you very much. And the prosecution.
Good morning, Your Honours. Helen Brady, Senior Appeals Counsel, appearing on behalf of the prosecution. And I'm here today with Mr. Reinhold Galmetzer, Appeals Counsel, Ms. Priya Narayan, Appeals Counsel, Mr. Matthew Cross, Appeals Counsel, and Ms. Navedha Tharu, Associate Appeals Counsel. Thank you very much.
Thank you very much. This is a non-authoritative summary of the Appeals Chamber's judgment in the appeal of the Hashemite Kingdom of Jordan, called Jordan from now on, against the decision of Pre-Trial Chamber 2, issued on the 11th of December 2017. That decision is informatively titled, quote, Decision under Article 87, Paragraph 7 of the Rome Statute on the non-compliance by Jordan with a request by the court for the arrest and surrender of Omar al-Bashir, unquote. In the familiar parlance of this court, I will from time to time refer to that decision as the impugned decision. We begin with the background. At all times material to this appeal, Sudan was not a state party to the statute of the International Criminal Court, popularly known as the Rome Statute. But it was a member state of the United Nations and was bound as such by the UN Charter. For a period of time leading up to the 31st of March 2005, the UN Security Council had harbored persistent worry that the situation in Sudan, specifically in the Darfur region, amounted to a threat to international peace and security and to stability in the wider region. And they said so in a number of Security Council resolutions. Finally, on the 31st of March 2005, the UN Security Council adopted yet another resolution, Resolution 1593. They adopted it on the basis of their powers under Chapter 7 of the UN Charter. In that resolution, the Security Council referred the situation in Darfur to the ICC prosecutor. It helps to keep in mind that it is under Chapter 7 of the UN Charter that the Security Council is empowered to try and contain not only breakdowns in international peace and security, but also threats of such breakdowns. It was precisely with such a threat in mind, in relation to the situation in the Darfur region of Sudan, that the Security Council referred that situation to the ICC. They did so upon the recommendation of an international commission of inquiry that the UN had earlier tasked to inquire into the situation in Darfur and to suggest what could be done about it. 4 years later, on the 4th of March 2009, the Pre-Trial Chamber 1, at the request of the prosecutor, issued a warrant for the arrest of Mr. al-Bashir, who was the president of Sudan at that time and at all times relevant to this appeal. That warrant of arrest concerned allegations against Mr. Bashir in the nature of crimes against humanity and war crimes. On the 12th of July 2010, a second warrant of arrest was also issued against him. What was special about that second arrest warrant was that it concerned a new charge of genocide. The warrant of arrest, together with requests for the arrest and surrender of Mr. al-Bashir to the court, were notified to all the Rome Statute states parties, including Jordan. In the meantime, Mr. Bashir visited a number of states parties to the Rome Statute, but they did not arrest him. This resulted in a series of pre-trial chamber decisions on whether or not to refer these states to the Assembly of States Parties and to the UN Security Council. As mentioned in the judgment, in the context of certain discussions, those states parties included Chad, the Democratic Republic of the Congo, Djibouti, Malawi, South Africa, and Uganda. In March 2017, Jordan hosted the 28th Summit of the League of Arab States in Amman. Mr. al-Bashir attended the summit on the 29th of March 2017. Jordan did not arrest and surrender Mr. al-Bashir while he was in Jordan. That is why we are here. In declining to arrest and surrender Mr. al-Bashir to the court, Jordan based itself on an understanding of Article 98 of the Rome Statute. In Article 98(1), this is said, quote, "The court may not proceed with a request for surrender or assistance which would require the requested state to act inconsistently with its obligations under international law with respect to the state or diplomatic immunity of a person or property of a third state unless the court can first obtain the cooperation of that third state for the waiver of the immunity." Unquote. And Article 98, paragraph 2 says this, quote, "The court may not proceed with a request for surrender which would require the requested states to act inconsistently with its obligations under international agreements pursuant to which the consent of a sending state is required to surrender a person of that state to the court, unless the court can first obtain the cooperation of the standing state for the giving of consent for the surrender." Unquote. Following the Arab League summit in Jordan, Pre-Trial Chamber 2 issued the decision that is now under appeal. In that decision, the majority of the Pre-Trial Chamber held, 1, that Jordan had failed to comply with its obligations under the statute, and consequently, 2, that Jordan's non-compliance should be referred to the Assembly of States Parties under the UN Security Council in accordance with Article 87, paragraph 7 of the Rome Statute, which allows such a referral. In arriving at that decision, the pre-trial chamber considered whether Mr. al-Bashir, when attending the Arab League summit, enjoyed immunity from arrest as Sudan's head of state. The pre-trial chamber found that in view of Article 27, paragraph 2 of the Rome Statute, there is no head of state immunity if the court requests a state party to the Rome Statute to arrest and surrender the head of state of another state party. The pre-trial chamber also found that in the case of a referral by the UN Security Council, such as was done under Resolution 1593 of 2005, Sudan, although not a state party to the Rome Statute, had, nevertheless, the same obligation that binds Rome Statute states parties to cooperate with the court, for that was precisely the effect of such a referral by the Security Council. In those circumstances, held the pre-trial chamber, Mr. al-Bashir could then not invoke head of state immunity, and because he could not invoke that immunity, there was no immunity to be waived under Article 98, paragraph 1 of the Rome Statute. Therefore, that provision did not apply. Concerning Article 98, paragraph 2 of the Rome Statute, the pre-trial chamber held in the first place that it could not determine whether Sudan was party to the 1953 Convention on the Privileges and Immunities of the Arab League, which provides for certain immunities in certain contexts of the Arab League. In any event, held the pre-trial chamber, the 1953 Convention was irrelevant to Article 98, paragraph 2 of the Rome Statute. Therefore, Article 98, paragraph 2 also did not apply. On the 21st of February 2018, the pre-trial chamber granted Jordan's request for leave to appeal the decision. In granting leave, the pre-trial chamber certified 3 questions for consideration of the appeals chamber. The issues boil down to these. 1. Whether the pre-trial chamber was wrong to find that the Rome Statute precluded immunity for Mr. al-Bashir as Sudan's head of state in any way that excuses Jordan's failure to comply with the court's request to arrest and surrender him. 2. Whether the pre-trial chamber was wrong to find that Security Council Resolution 1593 of 2005 negated any obligation that Jordan may have under international law to accord immunity to Mr. al-Bashir as Sudan's head of state. And 3. Whether the pre-trial chamber's decision to refer Jordan to the Assembly of States Parties and to the Security Council for non-compliance with the court's request was, in any event, an erroneous exercise of the discretion to do so. Appeal briefs were duly filed by Jordan, the prosecutor, and the Counsel for Victims, as well as by the Arab League, the African Union, and a number of legal scholars who had been invited to participate in the proceedings in the capacity known as Friends of the Court. States and the UN had also been invited to participate in the proceedings, but none of them took up the invitation. The appeal chamber received oral arguments and hearings that took place from the 10th to the 14th of September 2018. Following the hearings, the appeals chamber invited the parties and participants to file further written submissions on salient issues that might not have been addressed or addressed fully in writing or in oral submissions. The appeal chamber also invited the competent authorities of Sudan and Mr. al-Bashir to participate in the proceedings and express their views, but they did not take up the invitation. This is the background. Now, the judgment. The judgment of the appeals chamber is unanimous on the first 2 grounds of the appeal. This is notwithstanding that 4 out of the 5 judges of the appeals chamber Judge Morrison, Judge Opmansky, Judge Bosa, and I also append a joint concurring opinion to amplify the reasons for judgment on those two grounds. It is recalled that these are the grounds concerning the essential question whether Mr. al-Bashir enjoyed immunity in international law, notwithstanding or in view of A, the Rome Statute, or B, Security Council Resolution 1593 of 2005, such as would require the court to obtain a waiver of that immunity before requesting Jordan to arrest Mr. al-Bashir. The judgment of the appeals chamber is by majority on ground 3, Judge Ibanez and Judge Bosa dissenting as to that ground. It is recalled that this ground of appeal, the third ground, concerns the question whether the pre-trial chamber had exercised its discretion erroneously in deciding to refer Jordan to the Assembly of States Parties and to the UN Security Council, notwithstanding that Jordan may have indeed not complied with the obligation to arrest and surrender Mr. al-Bashir. I now turn to the appeals chamber's findings on the issues raised by Jordan under the first two grounds of appeal. As these two grounds are closely related, they have been considered together. On the first and second grounds of appeal, Jordan argued that the pre-trial chamber erred in finding that Article 27, Paragraph 2 of the Rome Statutes, which precludes immunity even for heads of state, had the effect of excluding the application of Article 98. It is recalled that Article 98, Paragraph 1, requires the courts to obtain waiver of any applicable immunity from one state whose official is entitled to that immunity before presenting to another state that is a party to the statute a request that may put that state in a position of violating the immunity in question. With respect to UN Security Council Resolution 1593 of 2005, Jordan first argued that the pre-trial chamber erred in finding that the resolution imported the application of the entirety of the Rome Statute to the situation in Darfur. Jordan's complaint is that the pre-trial chamber's finding means that Article 27 of the Rome Statute would apply to trouble the availability of immunity. In that regard, Jordan argued that the pre-trial chamber erred in finding that Sudan, although not a state party to the Rome Statute, labors nonetheless under the same obligations that the Rome Statute imposes upon its states parties, meaning that Article 27, Paragraph 2, which binds states parties to that statute by removing the immunity of their heads of state, would also bind Sudan, which is not a state party to the Rome Statute. Looking at the matter from another angle, the essential question of law engaged in the first two grounds of appeal on the facts of this case still remains this: whether the concerned head of state of another state, in this instance Sudan, would enjoy immunity where the court requested a state party to the Rome Statute to arrest and surrender that head of state. Now, the factual oddities to keep in mind are as follows. A, the state whose head of state is being sought for arrest is not the party to the Rome Statute, but B, that state is a member of the United Nations, and C, is the subject of a Security Council referral to the court in the terms of a Chapter 7 resolution that obligated that state, Sudan in this case, to cooperate fully with the court. All that is to say, putting it more plainly, that the central issue before the appeals chamber is whether Mr. al-Bashir, in his capacity as head of state of Sudan, enjoyed immunity before this court, with the result that the court was required to obtain a waiver of that immunity from Sudan before presenting a request to Jordan to arrest and surrender Mr. al-Bashir. One central question that dominated the discussion in this case is this. Even as a matter of interpretation of the Rome Statute, does customary practice accepted as law in relations amongst nations, otherwise known as customary international law, recognize immunity for heads of state, which immunity may be asserted to bar this court from the exercise of its proper jurisdiction? The appeals chamber has duly noted Jordan's complaint registered during the hearing that no question on customary international law was certified as such by the pre-trial chamber on an issue on appeal. But the appeals chamber considers that question as inevitably linked to issues on which leave to appeal was granted, since the immunity being asserted is described nowhere in the Rome Statute or in Resolution 1593 of 2005. And whether that immunity exists in customary international law is an important question that has troubled this series of litigation in the jurisprudence generated by various decisions of the pre-trial chambers on the question of immunity of heads of state. It is for those reasons that the appeals chamber invited the parties and participants ahead of the hearing to make submissions on the issue and gave them ample opportunity to do so. The appeals chamber will consider that question. The appeals chamber notes that the head of state immunity which Jordan asserts at the instance of Sudan is based on a manner of immunity that is clearly accepted in customary international law in certain circumstances. That immunity prevents one state from exercising its criminal jurisdiction over the head of state of another state. It is based on the principle of sovereign equality of states. And states being equal, no sovereign may assert jurisdiction over an equal. The principle is usually captured in the Latin maxim, par imparem non habet imperium, meaning amongst equals, none may exercise dominion. But there is a clear provision in the Rome Statutes that precludes immunity before this court. As indicated earlier, it is Article 27, Paragraph 2. It is certainly correct to see that provision in its own form as a provision in a treaty that binds the parties to it. The appeals chamber finds, however, that the provision represents more than a stipulation in treaty law. The provision also reflects the status of customary international law as it concerns the jurisdiction that an international criminal court is properly entitled to exercise. In that regard, the appeal chamber finds that there is neither state practice nor an impelled sense of such as law which would support the existence of head of state immunity under customary international law in relation to an international criminal court in the exercise of its proper jurisdiction. No submission was orally made or in writing, such as would truly contradict the appeals chamber's own findings as indicated, although the appeals chamber had invited submissions on the point. Accordingly, the appeals chamber has not found that customary international law preserves any immunity that afforded Jordan an excuse to decline the request of the court for the arrest and surrender of Mr. al-Bashir. In this regard, the appeals chamber is fully satisfied that the pronouncements made by the pre-trial chamber 1 in the Malawi referral decision and those made by the Appeals Chamber of the Special Court for Sierra Leone in the case of Charles Taylor, who was indicted before that international court when he was the sitting president of Liberia, had adequately and correctly confirmed the absence of a rule of customary international law recognizing head of state immunity before an international court in the exercise of its proper jurisdiction. The effect of absence of a rule of customary international law recognizing head of state immunity in relation to international courts is not readily avoided through the back door by asserting immunity that operates in the horizontal relationship between states, asserted in a manner that would effectively bar an international court from exercising its jurisdiction over the person whose arrest and surrender is requested. The law does not readily condone to be done through the back door what it forbids to be done through the front door. And indeed, this maxim serves a value in this appeal in more ways than one. I now turn especially to the effect of UN Security Council Resolution 1593 of 2005 concerning whether Sudan could invoke head of state immunity in relation to the warrants of arrest that the court issued against Mr. Bashir for allegedly committing international crimes in the context of the situation in Darfur. Resolution 1593 is a special jurisdictional trigger for the court. It is contemplated by Article 13, Paragraph B of the Rome Statute. That provision was intended as the means through which the ICC could facilitate the mandate that the UN Security Council has under Chapter 7 of the Charter to maintain international peace and security, or to contain threats to international peace and security. The direct benefit of this facility afforded by Article 13b is that the Security Council no longer needs to create new ad hoc international tribunals as it did in relation to the former Yugoslavia and Rwanda in 1993 and 1994, respectively. The ICC is now an international judicial mechanism at the disposal of the UN Security Council in the Council's effort to maintain international peace and security. As such, Resolution 1593 is a decision of the UN Security Council that is binding upon all UN member states according to the applicable provisions of the UN Charter, whether or not those UN member states are also parties to the Rome Statute. In that connection, the Appeal Chamber notes that Resolution 1593/2005 imposes upon Sudan a specific obligation to cooperate fully with the court. This means, in effect, that the cooperation regime for states parties to the Rome Statute is applicable also to Sudan. Moreover, the Appeals Chamber considers that the obligation to cooperate fully in accordance with the statute embraces all those obligations that states parties owe to the court which are necessary for the court's effective exercise of jurisdiction. Those obligations include those that merge into Article 27, Paragraph 2, ensuring that immunities that Sudan may otherwise enjoy under international law as a matter of its relations with another state cannot bar the court's effective exercise of jurisdiction. Since Sudan could not legally rely on the head of state immunity of Ms. Bashir, the Appeals Chamber considers that there was no need for the court to obtain the waiver of immunity from Sudan before the court could proceed with a request to Jordan for Mr. al-Bashir's arrest and surrender in accordance with Article 98(1) of the statute. That is to say, there was no immunity that needed to be waived. The pre-trial chamber committed no error in that regard. Similarly, the appeals chamber is not persuaded by Jordan's arguments alleging error on the part of the pre-trial chamber in finding that Article 98, paragraph 2 of the statute holds no accommodation for the 1953 Arab League Convention on Privileges and Immunities. The sum of the foregoing analysis is that Jordan did not comply with its obligation to cooperate with the court as it was bound to do under the Rome Statute. Finally, the appeals chamber notes that both Jordan and Sudan are parties to the Convention Against Genocide. Article 1 of that convention provides that the parties to it undertake to prevent and punish the crime of genocide. Thus, in view of the allegation of genocide engaged in the second warrant of arrest, Jordan was under an obligation to cooperate in the arrest and surrender of Mr. al-Bashir at the request of the court, not only because Jordan is a state party to the Rome Statute, but also by virtue of its being party to the Convention Against Genocide. All the findings of the appeals chamber that I have summarized so far, dealing with the first two grounds of appeal, are the unanimous findings of all the judges. Now I turn to Jordan's arguments under the third ground of appeal. This concerns pre-trial chamber's exercise of discretion to refer Jordan to the Assembly of States Parties and to the UN Security Council for non-compliance with the court's request for cooperation. As indicated earlier, it is Article 87, paragraph 7 of the Rome Statute that contemplates such referrals. In previous jurisprudence, the appeals chamber has examined that provision. In that regard, the appeals chamber noted that the exercise of discretion under the provision is subject to a factual prerequisite that needs to be met. This requires that the cooperation request that was not complied with must concern a matter of certain gravity. Neither party has raised on appeal the issue of whether the pre-trial chamber correctly established that factual prerequisite, but the appeals chamber addresses this issue on its own motion because of its importance in the inquiry, since the absence of that prerequisite would make a referral improper. The prerequisite engages the question whether failure to comply with a court's request for cooperation was a conduct that prevented the court from exercising its powers and functions under the Rome Statute. The issue, then, is whether that was the case here. And here, we recall the two arrest warrants that were respectively issued on the 4th of March 2009 and the 12th of July 2010. They were issued by the pre-trial chamber on the basis of the power to do so under Article 58 of the Rome Statute. A warrant of arrest, alongside its alternative of summons to appear, serves the function of securing the presence of the suspect before the court. It thus engages an important power that serves a fundamental function of the court. That is particularly so when the pre-trial chamber has decided that an arrest warrant is the more appropriate means of securing presence before the court. Given the importance of the indicated power and function, those who bear the obligation to execute an arrest warrant are not then free to render it nugatory merely by refusing to execute it. It is a finding of the appeals chamber that by failing to arrest and surrender Mr. al-Bashir, in circumstances in which Mr. al-Bashir was entitled to no immunity, Jordan prevented the court from exercising an important power and a fundamental function. As a result, Pretrial Chamber 2 was correct in concluding that Jordan's non-compliance prevented the court from exercising its functions and powers under the statute. The appeal chamber is also unanimous as to that finding. Yet, the question remains whether the pre-trial chamber's referral of Jordan to the Assembly of States Parties and Security Council was, in the particular circumstances of the case, an error in the exercise of discretion. It is noted that Jordan's main contention revolves around the pre-trial chamber's finding that Jordan did not truly pursue consultation with the court in order to seek to resolve any difficulties that Jordan saw as attending the request made by the court to arrest and surrender Mr. al-Bashir. Jordan further argued that the pre-trial chamber treated South Africa and Jordan differently by having declined similarly to refer South Africa to the Assembly of States Parties and Security Council when South Africa had also failed to arrest Mr. al-Bashir on an earlier occasion of his visit to South Africa to attend the conference of the African Union. The Appeals Chamber notes that Article 97 of the statute does not provide or compel a specific procedure regarding consultations between states and the court, nor does it set out the manner in which consultations should be done. The Appeals Chamber considers that in the absence of a prescribed procedure, the manner in which a state may indicate its intention to engage in consultations may vary. Some approaches may be more awkward than others, but what is essential is that the intention to consult is discernible in the circumstances. In this case, the majority of the Appeals Chamber is persuaded by Jordan's argument that their note verbal of the 28th of March 2017 amounted to a request for consultations with the court in terms of Article 97 of the statute. Judge Ibanez and Judge Bosa disagree. Contrary to the pre-trial chamber's finding, the Appeals Chamber considers that a state party's discernible indication of intent to consult is, in itself, a spur to the courts to engage, which should not be ignored. In addition, the Appeals Chamber finds, Judge Ibanez and Judge Bosa dissenting, that Jordan's note verbal of the 28th of March 2017 need not be seen as an advance notification of non-compliance. It is enough to see it as Jordan's way of identifying head of state immunity and the lack of its waiver by Sudan as perceived impediments to the request for Mr. al-Bashir's arrest and surrender, in relation to which consultation should take place. While it would be better for a state to approach the consultation process in an unequivocal manner of asking questions in need of resolution, the failure to follow that approach is not necessarily inconsistent with an intention to engage in consultation. A state may indeed approach the consultation process in the manner of stating a preliminary position that it sees as posing an obstacle to cooperation, thus engaging the question to be resolved. The Appeals Chamber therefore finds Judge Ibanez and Judge Bosa dissenting that Jordan's failure to put questions to the pre-trial chamber, choosing rather to set out its own legal position in the note verbal, did not preclude a view of the encounter as an attempt to engage in consultations. Accordingly, the chamber finds Judge Ibanez and Judge Bosa dissenting that the pre-trial chamber erred when it found that Jordan had not sought consultations with the court. In the view of the majority, this error of appreciation of Jordan's position materially tainted the exercise of the pre-trial chamber's discretion to refer. The error was notably implicated in the further error which the appeals chamber found, Judge Ibanez and Judge Bosa dissenting, that the pre-trial chamber had treated Jordan differently from South Africa in respect of the referral to the Assembly of States Parties and to the UN Security Council. The appeals chamber therefore finds, Judge Ibanez and Bosa dissenting, that the pre-trial chamber's exercise of the discretion to refer was accordingly tainted by error. In the outcome, the appeals chamber confirms the impugned decision to the extent that the pre-trial chamber found that Jordan had failed to comply with its obligations under the statute by failing to execute the court's request for the arrest of Mr. Bashir and his surrender to the court while he was in Amman on the 29th of March 2017. The appeals chamber reverses the impugned decision to the extent that the pre-trial chamber referred Jordan to both the Assembly of States Parties and UN Security Council on the ground that the pre-trial chamber's exercise of discretion was erroneous. Judge Ibanez and Judge Bosa dissenting. I shall now summarize the joint dissenting opinion of Judge Ibanez and Judge Bosa on the third ground of appeal and the eventual outcome of the appeal. While Judge Ibanez and Judge Bosa agree with the determination of the first and second grounds of appeal, and Judge Bosa also joined in the joint concurring opinion of the four judges in support of the appeals chamber's judgment on those two grounds, Judge Ibanez and Judge Bosa disagree nevertheless with the determination of the third ground of appeal and with the outcome of the appeals chamber's judgment, reversing pre-trial chamber's decision to refer Jordan to the Assembly of States Parties and the UN Security Council. Judge Ibanez and Judge Bosa are convinced that the pre-trial chamber did not err in that regard and that the decision to refer ought to be upheld. A summary of their reasons is as follows. First, for the reasons fully explained in the dissenting opinion, given that the objectives of the warrant of arrest issued against Mr. Bashir were frustrated as a result of the failure of Jordan to cooperate with the court, the failure prevented the court from exercising its functions and powers. As noted earlier, on that, all five judges are agreed. Second, Judge Ibanez and Judge Bosa found that the pre-trial chamber did not err in concluding that consultations did not take place in this case. The belated note for bail sent by Jordan indicated only a statement of Jordan's position that it would respect Mr. al-Bashir's alleged immunity from arrest. Jordan did not request any further concrete response or action from the court. Third, for the reasons set out in detail in the dissenting opinion, the pre-trial chamber did not err in affording a different treatment to Jordan as compared to South Africa. The circumstances surrounding these two cases were different, thus justifying the different treatments. This is particularly so considering, as the dissenting judges found, that while South Africa ensured future cooperation with the court in the arrest and surrender of Mr. al-Bashir, thereby making it unnecessary to refer the matter in order to foster cooperation, Jordan has not done so, thus warranting the impugned referral. Fourth, the dissenting judges are of the view that a failure to refer Jordan's non-compliance to the Assembly of States Parties and to the UN Security Council would be contrary to the object and purpose of the Rome Statute. That object and purpose being to put an end to impunity for the perpetrators of the most serious crimes of concern to the international community as a whole, thereby preventing the further commission of crimes and bringing justice to victims, in this case to the numerous victims of international crimes allegedly committed in Darfur. Fifth, as further explained in the dissenting opinion, the dissenting judges consider that past examples of referrals to the Assembly of States Parties of the failure of other states parties to comply with the court's request to cooperate in the arrest and surrender of Mr. al-Bashir demonstrate that the referral of Jordan's non-cooperation to that body has a very real prospect of yielding positive results in terms of future cooperation, thereby giving effect to the raison d'etre of Article 87, Paragraph 7 of the statute. Sixth, the dissenting judges consider that by refusing to cooperate with the court, Jordan infringed both its obligations of cooperation under the Rome Statute and potentially international obligations owed to the Security Council pursuant to the UN Charter. In the view of the dissenting judges, a referral of Jordan's non-compliance to the Assembly of States Parties and to the UN Security Council is required so as to allow the taking of those measures deemed appropriate to ensure future compliance, cooperation with the court, and thereby the fulfillment of the mandates of both the court and the UN Security Council. The dissenting judges consider that this referral is not punitive in nature or a sanction imposed upon Jordan. Rather, it is a call for action not only for Jordan but also for the members of the Assembly of States Parties and for the international community as a whole, with the aim of fostering cooperation with the court, thereby enabling the effective realization of the high values and objectives enshrined in the Rome Statute. Finally, for reasons explained in detail in the dissenting opinion, the dissenting judges find that in the case at hand, the pre-trial chamber was correct. It did not err or act arbitrarily and did not abuse its discretion. On the contrary, the pre-trial chamber was reasonable and fair when based on the particular circumstances of the case and after properly weighing all relevant elements and facts, and within the boundaries of the law, it properly applied Article 87, Paragraph 7 of the Rome Statute to refer to the Assembly of States Parties and the UN Security Council Jordan's failure to comply with the court's request to arrest and surrender Mr. al-Bashir. The dissenting judges would uphold the impugned decision and confirm Jordan's referral to the Assembly of States Parties and the UN Security Council for failure to cooperate with the court. This brings us to the end of the summaries of the Appeals Chamber's judgment and dissenting opinions. As always, it must be stressed that these summaries are not authoritative. They are intended only to convey the essence of the Appeals Chamber's judgment in an accessible language. It is important to caution in particular that in many instances different words and phrases have been used in this summary to convey the sense of what is said in the judgment. The authoritative pronouncements of the judges will be found in the judgment of the Appeals Chamber read together with both the joint concurring opinion of Judge Morrison, Judge Hofmansky, Judge Bashir and me on the first two grounds, and the joint dissenting opinion of Judge Ibanez and Judge Bosa on the third ground. The judgment of the appeals chamber and the joint concurring opinion will be published immediately after this sitting. The joint dissenting opinion will be published in due course. It is our tradition at this juncture to express our appreciation to all counsel who appeared in the proceedings. Your participations and particularly were very, very helpful given the high quality of written and oral submissions that we received. We also thank all the staff of the court who worked so hard to make these proceedings possible, not only those that we see in the courtroom, but also those who work behind the scenes, both closer to the courtroom and the more physically removed. They include, but are not limited to, the interpreters, the court reporters, the security staff, and all the other staff of the court. On behalf of the Appeals Chamber, I thank all of you. But before we adjourn, I received a note that the representative of the Arab League would like to put his appearance on record. It's enough to note that Arab League representative was in court today. Thank you very much. The court is adjourned.
All rise.